Welcome to Lady Justice, Women of the Court, a podcast hosted by Women State Supreme Court Justices and produced in partnership with the National Center for State Courts. In each episode, our hosts Justice Rhonda Wood of Arkansas and Justice Beth Walker of West Virginia discuss the law and its real-world implications for listeners of all ages. Join us for another insightful and inspiring conversation.
Hello and welcome to Lady Justice, Women of the Court. I'm Justice Rhonda Wood of the Arkansas Supreme Court, and I'm here with my good friend, Justice Beth Walker of the Supreme Court of Appeals of West Virginia. And this is our podcast produced in partnership with the National Center for State Courts, where we discuss anything and everything relevant to state courts in our aim to encourage transparency and civic education in the judicial branch. Today, Caroline Mackey is joining us to discuss a recent United States Supreme Court decision and its impact on the public's First Amendment right, as well as state court officials. Beth, how are you doing today?
Rhonda, it is so good to see you. I am doing great. I can't believe it is April already. We are recording this in the middle of April, and we are almost, we're seeing the end of our January term of court. It's going really quick, so everything is great. How about things in Arkansas?
So things are going well. I think that our court may actually finish early this term, so that may be a big surprise. So we go till we finish with our cases. So any case that's ready for submission, and when we run out of cases, we end. So I think that we'll be done mid-June. So that's pleasant for us at the Arkansas Supreme Court. As I mentioned, Caroline Mackey is joining us today as our guest. And so let me introduce her and tell our listeners a little bit about her. Caroline is an attorney in North Carolina, completed her undergraduate work at University of North Carolina. So I guess she's a Tar Heel fan, and has some basketball bragging rights this year, unlike Arkansas. I won't even go there. Caroline has been recognized on most of the North Carolina up and coming list, from Young Guns Legal Elite to Rising Star. And what Beth and I care a lot about is Caroline is very active in pro bono work, especially with guardian ad litem representation and appeals. She is also a partner at Poynter Spruill, a large law firm in North Carolina, a mother of four, just recently having her fourth little girl in January. And so she's interrupting her maternity leave to be with us. So Caroline, welcome to Lady Justice.
Thank you both. I'm really excited to be here and talking with both of you today.
So we are thrilled that you're with us and discussing sort of the status of the law after the recent March decision in Lindke versus Freed. And the question in this case was sort of what factors apply when determining if a public official's social media activity is state action, such that the official's decision to selectively block access has constitutional implications. Beth and I have always been open on here about our beliefs in judges using social media to promote civic education about the judicial system. And we talk a lot on social media about the work of our court. So this case has implications for how really any state official or state actor uses social media going forward. Caroline participated in the SCOTUS case by submitting an amicus brief. So she brings a unique insight that we hope can inform anyone. And I'll protect you a little bit, Caroline, is that you're not here to give representational advice to do that. But can you begin by telling us just a little bit about the background of the case?
Sure. So this case is really a showdown between a city manager from a city in Michigan, James Freed, and a citizen who the court referred to as a gadfly, that's Mr. Lindke, over blocking and deleting comments on a Facebook page. So Mr. Freed, like many of us, had a personal Facebook profile. And at some point, he turned it into a page where more people could see it. And his page had a lot of personal stuff on it. He had a lot of pictures of his family. But he also posted updates from his job. He had his job title. He had a picture of him in a suit with a city pin on his lapel and a link to the city's website. He also used the page to pass on information from the city. So he would post things, he would solicit feedback about official city business. And Mr. Lindke was a prolific commenter on a lot of those things, particularly with pandemic related posts. Mr. Freed was posting updates about the city's response. Mr. Lindke didn't like the way the city was handling a lot of it, so he commented. And eventually, Mr. Freed just blocked him completely. So the question in the case was whether there was state action when Mr. Freed blocked Mr. Lindke. And that is, was Mr. Freed acting as the government? And if so, then that could raise First Amendment problems. But before you even get to the First Amendment question, you have to figure out, is this individual acting as the government? So that's the background of the case, which is pretty interesting and pretty common, I think, for a lot of public officials across the country.
As I was reading the facts, of course, it felt very familiar to me because many of us, of course, started on Facebook, some of us before we were public officials, and then our Facebook or Twitter or whatever presence sort of morphs as we progress in our service, or we are in those of us who run for election in states, it becomes a self-promotion site, and then it becomes a public communication site. And is it personal? Is it private? So I think these facts, although maybe I guess some of these best cases come up as I like how you called it, a showdown between the two parties in a smaller size town, which is very familiar here in West Virginia, and I know in Arkansas as well. But I guess I would love for you to talk a little bit more about, how does a citizen get a First Amendment right when we're talking about, I realize, and we'll talk more about sort of state activity, and that's sort of the key to it, but how does a person get a First Amendment right or acquire that kind of right when we're just talking about Facebook?
Yeah, the members of the public have First Amendment rights to comment on what the government is doing. It's what the First Amendment protects, and that's sort of the highest protected speech you can have is matters of public concern and matters about your government. So if Mr. Freed's Facebook page is just an extension of the government, then the government can't choose who says what about what it's doing, and without raising that First Amendment inquiry. And but on the other hand, public officials also have First Amendment rights. So you all have the right to talk about your jobs, to go out and campaign and to share updates about what the court is doing. And just because you're doing that doesn't necessarily mean that you're acting on behalf of the government. And so Mr. Freed also had his own First Amendment rights. Does he have to keep comments that he doesn't want publicized on his page if it's truly personal? And that's sort of the difficulty here. And the reason the court had to decide this case, it's not an easy question. It's the Supreme Court doesn't get easy questions. And you're right. A lot of people have Facebook pages. They talk about their jobs on their Facebook pages. And when you're running for election, it's even more so, because those campaign pages, once you get elected, turn into the page of Justice Wood.
I like that you said that that the Supreme Court doesn't get easy cases, because Beth and I both are from states that elect your Supreme Court, our state justices. And so when we're out there, people are like, I can't believe the court ruled this way. That seems so easy. And I was like, yeah, if it's in front of our court, it wasn't easy. And so it's refreshing to hear a lawyer say that. So thank you for saying that. So one of the interesting things to me, and one of the reasons that we reached out to you, was that you filed an amicus brief in the case in front of SCOTUS. But when I was looking at your brief, you did not take a position in the outcome of the case. And so that is a little unusual, but can you sort of explain how that happened?
Yeah.
But first, be sure to let everybody understand what amicus.
Oh, maybe,
We know
yeah.
what
Sure.
amicus brief
Amicus,
is.
sure.
So the term means friend of the court, and it's essentially third parties who are not involved in the underlying case who file briefs to help the court. And generally, you file a brief in support of one side or the other, and you say, court, you should rule in favor of this party for these reasons. We're the experts on this issue. Here's what we have to say about that. In this case, and like I said, this was not an easy case. It was a team of us. So we worked closely with our clients, multiple Zoom calls to figure out what we wanted to say in this brief. And then our team at the firm, and there were about 5 of us. I'm the only one here today, but this was certainly not my work. There are lots of people who had a lot more time and effort and hard work put into the brief that we filed. But we had multiple conversations discussing and debating these issues to figure out, what do we want to say to the court that would be helpful? And what do we want the court to do? And the most important thing that we thought the court should do was articulate a test that public officials and local governments, that we were representing a coalition of local government organizations, but we wanted the court to put forward a test that was easy to apply, that we could train local officials on, that courts could apply. So this question is going to come up in courts. It already has. And for the judges who are deciding these cases, it should be that the results are the same no matter where you are. And some of the tests that were put forward, we just felt like were a little too loosey-goosey, were difficult to apply, would lead to inconsistent results. And so we said, court, first of all, please just step forward a clear test. And we didn't really care what the outcome was in these cases. And we said, whatever you think, just make it so that we can understand it. And that's why we ended up filing in support of neither party. We probably would have filed a brief that just said, hey, court, please articulate a clear test and not say anything else, but it would be about a page. We did end up proposing a test that we wanted the court to adopt. But we didn't weigh in on the ultimate conclusion. And actually, neither did the court in this case.
And a short, quick sidetrack on this phenomena of amicus briefs. Let me ask you, Rhonda, are there amicus briefs in Arkansas in front of the Supreme Court?
There are quite often, both in the civil and criminal context. And we have a case right now. I think there's 5 amicus on the civil side. That it's a lot, and none of them are. And I guess I would say, Caroline, you really were a friend of the court because you took no position and you're just like, court, here's some helpful sort of tests. But yeah, we do quite frequently. And they have to get permission from the court to file. And of course, can't coordinate with either of the parties. We have some, specific roles in Arkansas, but we do not allow them to have oral argument unless the parties cede part of their time to them. So that's one thing that happens in Arkansas. What about you, Beth?
So we have amicus briefs, appearances, I guess you would say, in West Virginia as well. Not very often, I have to say. We actually sit and discuss once in a while that we wish that someone was paying attention, that and that we had a means to encourage friends of the court to come forward. And I guess I'm not even going to take a position on whether it's amicus or amicus. I suppose we could get into that whole thing. I started by saying amicus, so I'll just continue down that track at this point. But I guess the $64,000 question for you, Caroline, or one of them is, did the Supreme Court of the United States provide the clear path that you encouraged them to give by providing a test? We love tests in the law. There are prongs and factors and everything. And did they fulfill your expectations, or I guess most importantly, the expectations of the parties that you represented before the court?
think they did. We were pretty pleased when we saw the court's decision. I mentioned that the most important thing to us was that a clear test be provided, but we also put in our brief, here's one possible test that you could adopt, and we called it the authority test. And it basically asked, does this individual have the authority of the government behind this, this speaking on behalf of the government, this Facebook page, whatever it comes out as. And the court sort of adopted that. We were pretty pleased with what the court ended up adopting. So I sort of see it as an authority test, but context matters is how I've been describing it. So you have to have the authority of the government. And then you also have to purport to exercise that authority to be speaking or acting as the government. So that's the authority can come from a statute, an ordinance, policy. So express things like that. It can also be implied. Custom or usage. As Chief Justice, are you typically speaking on behalf of the court? Have your predecessors always done this sort of thing? So that part I think is pretty clear. That's a threshold question in this threshold question analysis of state action. Do you have the authority to speak on behalf of the government? And then the second part is are you actually trying to speak on behalf of the government? So the court puts an example in the opinion that's a public official, I think it was a mayor, may make an official announcement at a city council meeting. And then he may say the exact same thing the next day at a party with his friends. In one of them, he's purporting to exercise that authority to speak as the government. And the second one, he's not. And so that matters. The context matters of what you're saying. Will there still be cases that grapple with these issues and figure out, okay, is there actually authority here? And was the official actually purporting to exercise that authority? Sure. That's why we all have jobs, right? There's nothing is just clear cut in the law. But I do think what the court put forward is easier to teach and to train and understand than some of the other tests that were proposed. And if I can speak a minute about that, some of other courts they used what they called an appearance and purpose test. And so that's actually looking at the social media page and looking at the content of it and looking to see if it had the trappings of an official page. And to us, the more we talked about this and the more we grappled with these issues, we felt like that's so hard to train. Where do you draw the line? If you're mixing personal and public posts, if you've got pictures of your family and you're passing on government announcements and you're asking for public feedback and then you're posting vacation pictures, how do you train that? How do you answer that question? And so the court did not adopt that test, which we thought was better. We thought there has to be some authority to do this. And we put in our brief an example of a sanitation worker in a city who has no authority from the government to speak on behalf of the city, but makes his Facebook page look like it. And is that enough to bind the government to a First Amendment analysis? And that was our concern.
No, I think that makes perfect sense. And so it sort of allows, in some respects, that people that are just trying to be helpful within government sort of pass on and share information about what's going on in the city or city governments or state governments, state courts, but don't really have any authority. It gives them, I think, a little bit more freedom, under this test. But I think probably for those of us maybe on the Supreme Court, state Supreme Courts, probably not so much. So I'm going to digress a little bit and go, because I was talking to one of my law clerks this morning, and what he said, is there a difference between blocking and muting? So someone, and he said, well, so I know you can't, people, post kind of offensive or, things. And he said, we don't have to actually block them from your Facebook page or whatever, but you can mute sort of their comments or conversation for, 30 days or something. And I said, I think under the First Amendment, I don't know that there would be a difference. I was like, I don't know. I have to wait till that case came up in front of us. But do you have any thoughts on that?
The court did talk a little bit about what they called mixed use social media. And they said if you're mixing personal and business and you block somebody completely, that's likely problematic. Mm-hmm. But if you've got this mixed use and, somebody comments, we talked about this example a lot as we were writing the brief, the ugly baby. You post a picture of your baby and somebody says, well, that's an ugly baby. Yeah. And you delete that comment, you're probably okay under the First Amendment. So, it's going to depend on the case and the facts that come up. Right. Every lawyer's favorite answer, it depends.
Right.
But I think there is a difference in blocking versus muting or deleting comments. But it also, as the court says, you have to first decide if they have the authority. And if they don't, then you don't even get to that question, because if the public official is acting in their personal capacity, then yes, they can block, they can delete. You don't have to have you don't have to see somebody telling you that you have an ugly baby. That's the First Amendment protects your right to delete those comments.
That's right. Well, do you have tips for state judges going forward or state actors?
Yeah. I think the court gave us some pretty good tips. Justice Barrett wrote the decision. And actually in oral argument, she posed a hypothetical of, could her law clerk create a page and say, this is an announcement from Justice Barrett's chambers? And no, they could not. That sort of gave us a hint about this authority question. But she makes clear that a disclaimer on your page is not necessarily dispositive, but it can go a long way. So if you have a disclaimer at the top, this is the personal page of Justice Beth Walker. The views expressed are those of Justice Walker and not of the West Virginia Supreme Court. Well, I'd called it the wrong name.
Oh, you got it. You got it right.
Yes. Okay. Okay. That's not going to answer the question, but it's going to be a pretty big hurdle for somebody to say, oh, this is the government blocking my speech, if she were to then delete comments or block somebody from that page. So that's the first tip. Put a disclaimer up if you've got a social media page where you're posting things about your job. The court also says, you have to have this authority. So the next question would be, figure out if you even have the authority. There was a companion case, O'Connor, and it was the school board, and it was 2 school board members. And, in that situation, 2 school board members don't have the authority to act as the board. It takes a consensus of the board or a majority of the board. So figure out if you even have the authority to speak on behalf of the government as an individual. If you're a mayor or a chief executive, you might. If you're one member of a governing body, you might not. So figure that part out before you post or delete or block people. And then I guess the next tip would be careful with those mixed messages and mixed usage pages. Even though you have to have the authority first, you still should be careful and not make your page look like it's a pronouncement of the court, just so you don't risk those First Amendment violations.
And of course, as we've discussed, you and your clients felt like you got a win, so to speak, if anybody wins in court, because you asked for a clear test and you feel like the court provided you with a clear test. But could you help our listeners, particularly maybe students? We have a lot of variety, not just lawyers who listen. Who won in this case? Did anyone win yet? with the Supreme Court's decision and what happens next?
Not yet. The court sent it back and they said, here's the test. Now go back to the lower courts to apply it, which I'm sure you all do in your jobs and maybe even see sometimes from the U.S. Supreme Court, depending on if you've got those cases that go beyond your courts. So we don't know in this case, but if I had to guess, I'm going to say that there was no state action for Mr. Freed, and Mr. Lindke is going to be out of luck moving forward.
But from a technical perspective, I guess the showdown continues for further factual development by the lower court, as we say commonly. So then I certainly don't want legal advice, but obviously this opinion gave all of us who participated on social media an opportunity to think about what we're doing more frequently. I have to admit, I've not been as active on social media, not because of this case, but it's just been kind of a cesspool lately. And I just haven't loved being on social media. Although I'm out there and I still think it's a great way to promote things. I'm trying to find a way to keep with the positive. So I want to be out there and I want to do it safely and smartly. So here's a hypothetical that may or may not be actual, but for a while on Twitter, I haven't done it this term, but I consistently would tweet out we call it the argument memorandum, but the list of the oral arguments that are happening on a given day and what lawyers are actually arguing. And it was a little personal feud between me and the former clerk of the court because she refused to put it on our website. And I said, fine, I'll tweet it. And so I'm curious when that I would have been a public official, state Supreme Court justice, probably maybe with the authority, although no specific authority, there's no constitution or statute that says a justice of the court can distribute the memorandum of the proceedings of the day. Although nonetheless, absent that, and just based on my authority, and then the fact that I was the only state actor distributing that memo. I know this is a long rambling hypothetical, but does it sound like I'm running into an area where the First Amendment might be triggered?
Don't you love oral arguments?
You didn't know you were going to get.
I knew
that's what was coming.
Did I sign up for that? But let me point to something in the court's opinion to help shed light on your hypothetical. The court talks about an official doesn't necessarily purport to exercise that authority that's given to him or her just by posting about your job. Justice Barrett says he might post job-related information for any number of personal reasons, from a desire to raise public awareness, which sounds a lot like your hypothetical, to promoting his prospects for re-election, which could also play a role in said hypothetical. Moreover, many public officials possess a broad portfolio of governmental authority that includes routine interaction with the public, and it may not be easy to discern a boundary between their public and private lives. Yet these public officials too have the right to speak about public affairs in their personal capacities. So the court says when there's doubt, additional factors might cast light. For example, an official who uses government staff to make a post will be hard-pressed to deny that he was conducting governmental business. So that's where these questions of, are you using government resources? Is your Twitter account passed on from, successor to successor? Where those sorts of factors that really showed up in the appearance and purpose test play a role. But just because you're posting information about your job doesn't necessarily mean you're speaking on behalf of the government.
Well, thank you for indulging me with that hypothetical.
Without exactly answering it. I don't know.
No, you did though. I mean, that's the whole point, I think, of, reading this opinion by Justice Barrett. It is going to be very fact specific. And as a public official, it seems to me that it's incumbent on us as part of being responsible on social media to follow the guidelines that we have been provided, using an appropriate disclaimer, being mindful of who's talking. Obviously, we have a court social media presence as well, which of course is state action, I'm quite sure. And, deciding what I do personally versus what I encourage our court social media folks to do is probably another way to be smart about all of this. But go ahead.
The use and the reliance on social media is just prolific and has increased over the years and is probably only going to increase. And so many people get news through social media, and so many people convey news through social media, and people govern through social media. We've seen that in our country in the past. And I've been in a city council meeting where the council meeting is streamed on Facebook, and a public official, an elected official, says they're telling me on Facebook that they can't hear. And so the official is there in the meeting governing while also being on social media and interacting with the public through Facebook. So it's a very important question, and it's a good thing that the court decided it, because it does impact so much of our lives and so much of our jobs and what we are doing.
It truly has become sort of the new public square. So before we shift gears a little, Rhonda, what other questions do you have about this case? Or I won't say put a hypothetical out there because I don't want to put Caroline through it. We didn't warn her, but I'll turn it to you before we switch gears.
No, I was just thinking, and I don't know, Beth, if you've ever had, but we get, comments that you certainly, and people that you would want to block, when we're interacting on social media. So, I was telling like I said, I was talking to my law clerk this morning about this episode, and I told him that there was one particularly, member of the press that was not the kindest in the past, one election cycle, and would always tag me in these terrible things. And I just reached out and was like, listen, this is my personal, my parents are following me. And I was like, tweet all you want, whatever stories you want to write, but do you mind not tagging my personal? And, here's a campaign site, tag it or whatever. And the person was like, oh, okay, I'm sorry, I didn't realize that. And so switched. I was like, okay. I was like, knock yourself out with your stories. Do you mind? And so it worked out, it's fine. So sometimes it was, just kind of, I don't know if you've had that experience, Beth, but just kind of being open and, hey, we're normal people, and,
I haven't had that experience with a member of the press, and it sounds like I don't know that I would have been as nice as you were. You were clearly very effective about it, but I have had from time to time to deal with the sort of troll issue, which is some, person, I think for the most part, not even known to me, who's just out there trolling or, just trying to stir things up. And, by and large, I had a couple of accounts that were blocked, and we had a whole conversation about, because I'm obviously trying to be responsible with this. And we had a whole conversation about, well, should I block people at all? And is this about me not having to read all of this stuff? Or am I, by being out there, is this just part of, we all have to accept that there will be terrible things said about us in these roles. That's just part of what we do. But it certainly, was something I had to deal with. Not much lately, to be honest. Hopefully this episode doesn't trigger anything, but not too much lately.
Do you both have social media pages, or have you had them for election cycles?
Yeah, I'm in an election cycle right now. And so, for Facebook, I have an election one that's separate from my personal. But Twitter, I just have one Twitter account. And so it's definitely mixed use. It's not bad. Social, the Facebook definitely, there's sometimes unpleasant, but I just ignore them.
Well, and it points out sort of being smart about it, because as a practical matter, I've had a Facebook personal account forever. And then I had an election Facebook account, which was separate, which then we morphed into sort of an official-ish to have something separate from my personal. And so then I have two, and one is public, as Mr. Freed's was, where he converted it so that he could have more Facebook friends. So it certainly makes me, want to step back and just make sure I'm making a decision about how I'm using these, instead of sort of letting it evolve as the medium evolved, to be honest, because, some of us have been on Facebook since, for a long time. I probably got on in 2008 or something. So some of it has been kind of organic, like, as I'm sure many folks who are in public positions probably have the same situation.
So I was just pulling up my Twitter profile, and it does say, besides saying like mama for human mom, by the way, of two more of my dogs, everything else, but it does say tweeting is personal only, not a reflection of future decisions or endorsement. I don't know if that's enough, or if I need to like tweak that a little bit more.
Well, and mine doesn't
think
have
about
the
that,
disclaimer.
Caroline.
Mine doesn't have the disclaimer at all as I look at my Twitter.
Oh, really?
No. So, well, because I ran out of characters. I wanted to say all these things and mention that I'm a golfer and a Girl Scout and all the things. So now I'm going to have to give up some of the, and I don't know if Musk is allowing those of us who used to be blue checks and are, don't pay for our blue checks anymore, if we can have more profile. It's all, a consideration.
Caroline, you've sparked us to go through and look at a
little social media housekeeping is not a bad thing.
Yeah, I think that we'll be looking at all those accounts and trying to make sure we've got it all lined up. I will say that, and we're digressing, but the harder thing that I've noticed running this cycle that I've never had in the past, this is my 6th election cycle that's changed, is litigants contacting me by social media, and particularly incarcerated ones, that now there's so much access to social media by people incarcerated. And so that's starting to be a challenge, I think. So that's kind of been unique. This has been a change. So
it's certainly something to manage. Caroline, are you on social media? Has this involvement in your case changed your social media habits?
Well, I'm just a regular old private person. I am on social media. I have an Instagram account, and that one is private. So I have to accept you before, and I do post pictures of my family and my kids on that one. And then I do have a Facebook account, and I have had a Facebook account since it started. I went to UNC for undergrad, and I think Facebook started at like 5 to 10 schools, and UNC was one of them. And I created this page and had no clue what the purpose of it was, but I did it because everybody was doing it. So I've had one since probably 2004. And I'm not super active, but it is a good way to keep in touch with people. And
as we digress completely, that I had this conversation last week with my staff. So I feel like I'm getting so old, that what a Facebook actually was before the digital Facebook, because Beth knows one of my law clerks, Brian. He went down to our library and found like the Facebook from when I graduated law school, the actual book with our faces. And because he was making fun of me and showing my picture around the building. And so, and I said, well, that was the original Facebook. And I was explaining that it used to be in colleges. That's how you would get a Facebook when you started college or law school with everybody's faces in it. That was a physical book. And they looked at me like I was from another planet. So anyway.
So you're not that old, Rhonda, but yeah, it is kind of humbling.
We're about the same age, Beth.
And we have those
we don't
conversations
want to
with our
you don't want me to admit that we're old.
But nonetheless, we do have a lot of listeners who don't think that we're too old to listen to, which makes us feel good. And we love to have our guests, Caroline, hear from, speak to our listeners about really anything, advice that you have for younger lawyers, newer lawyers, people you've obviously achieved. As Rhonda mentioned at the start, you've been recognized in the state of North Carolina for the excellence of the work you do, and you're obviously doing it while balancing your personal responsibilities with your law firm achievement. So what advice on any of that do you have for our listeners?
Oh, well, I don't know how well I'm balancing it. Let me say that first of all. It is a challenge day by day, sometimes hour by hour. But I'm lucky to be at a firm that does support women. I have 4 kids under the age of 7 and a husband who works full time. And it's a lot. It's a lot. I'm not going to lie. It's a lot. But I got lucky to be at a place that helps me do both and that offers support. I can do interesting work for good clients while also still being a mom to my kids and being there for my family. And so I guess my advice is to find that support in whatever way you can, whether it's a supportive partner, a network, a mentor, a place of employment. Find that support because nobody can do it alone. And you have to give yourself grace from time to time. You can't do it all. So if some things have to slip a little bit, that's okay. I don't have it all figured out, and it's okay.
So, of course, we have a lot of young women listening too, and so I guess I'll give you kind of 2 questions. You can answer either one. One is we have seen a lot of women leave sort of bigger law and larger law firms when they, start having children and they find that the practice is difficult. And so I'm curious, again, how you've managed that, and with the balance in your firm. And then also just your sort of mixed use sort of practice and representing these clients, governmental entities, and doing this really interesting litigation and appellate work practice, and how you sort of develop that area of the law. I think some of our listeners would love to know how you got into that. So you can answer both, or like I said, you probably now don't want to appear in either of our courts or an oral argument.
Well, I'm not licensed in neither. So you probably don't want me to appear in your courts. To answer the first question, I think I would just go back to that support network. I do, when I had my second and third kids, they're twins, so they came at the same time. So going from 1 kid to 3, and that was 3, 2 and under, was difficult. And I reduced my schedule a little bit at the firm. And I think a lot of women lawyers who have kids and are trying to manage and balance all of these things will do that during at least children's early years. And so I'm lucky that I could reduce my schedule a little bit. It still feels like I work full time, but it's just enough to take a little bit of the pressure off. So that's one way that I've done it. And then just getting support, having people who are understanding and compassionate about, I'm going to need you to cover this because daycare just called me and I've got to go, kind of thing. That's been really helpful. Your second question was about my specific area of practice, and it is varied. So I would say 50% of my work is government related, constitutional, a lot of election related work. And then the other half is more business litigation, contract disputes, professional liability defense, financial service representation. And that keeps it interesting. It keeps it busy, which is good. I got lucky to be the brand new associate at my firm when one of our senior partners was getting ready to file redistricting litigation back in 2011. So I was the one who was researching Section 1983 claims and helping to get some research to put together this lawsuit. And then it just sort of snowballed from there. And we kept doing those cases. Those are not short cases. They often last a decade. And that just sort of built a practice from that. And I've transformed it a little bit to working more with local governments and helping them redistrict and helping them with election issues that come up, because they come up all the time. It's a very busy practice area. And that part of my job is really fun and challenging. I will be honest, it can be very challenging. So I wear a lot of hats. But speaking of election work, I'm curious about your experiences in elections. I asked you already about your social media pages, but in North Carolina, we've gone back to partisan labels on the ballot for judicial races. And judicial elections are hard. I'm the only lawyer in my family. Family members reach out to me every single election where there's statewide judicial candidates on the ballot, and they say, who should I vote for? And in North Carolina, they put the party labels back, so that gives some indication. But I believe you're both in states where your elections are nonpartisan. So I'm curious about what you see as the challenges, what you see are the benefits, what's fun about and enjoyable about running statewide. And maybe Rhonda, since you're in the midst of it right now, you want to go first. And
oh boy, I don't know when I'm in the middle of it right now, if it feels very fun. So Arkansas is unique in some respects. So our general election is in the primary. And so that makes it in a presidential cycle, our primary moves up. So normally it's in May, but it's in March, so that we get to be part of the whole try to make Arkansas relevant in the presidential cycle. My seat is not up. I'm running for the Chief Justice slot, but there were 4 of us that ran. And so 2 of us then were in a runoff, but then they push our runoff to November. So I have been running for over a year, and then my runoff is all the way to November. So it is torturous in that respect. But running in the when everybody else has a partisan primary is sort of like running in a straitjacket, because all of the events are primary events. And so they're party affiliated events. So you're sort of going to one party and the other party, they're split. And there aren't very many opportunities to appear jointly at nonpartisan events, even though you're nonpartisan. And so that is difficult, but that's also the only thing that I've known. Like I said, this is my 6th election that I've ran. So I've sort of you adapt with what you know. But it's very difficult. And I've said before that you go to one party event and everybody stands and claps for a certain issue and you can't respond. And so they think you're against their particular issue. And then you go somewhere else and they stand and clap for the other side, and everybody thinks you're against everything, basically. So it's very difficult to do. But I think that we are not partisan on the bench. So none of my decisions, hopefully, would be affiliated with for a certain party. I have a judicial philosophy, but I don't have a political philosophy on the bench. So in that respect, I'm fine with a nonpartisan sort of label. But Beth, you've been both. Beth's ran both ways, because West Virginia had switched sort of. So do you want to comment?
Yeah. So when I ran in 2008, first unsuccessfully, it was a partisan race for Supreme Court. And, we ran in the primary and then in the general, and it was, I came very, very close, was not successful. And that's all I knew, the process. But I always said when asked about it, because people would talk, should it be partisan, not partisan? I would always say, I think these should be nonpartisan because, we all believe as judges, or we should all believe, in my view anyway, that it doesn't matter what party you are. It doesn't matter the parties of the people in front of you. We are in charge of administering the rule of law and coming up with the correct result under the facts and the law that we have. And so none of that's partisan, or at least in my view, it shouldn't be. And so I got laughed at because, these will always be partisan. Well, a few years later, our legislature, under its authority under the Constitution, changed the judicial races to nonpartisan. And I was the first justice elected in a nonpartisan race. And we are in the primary, as in Arkansas. So our judicial elections are in May. And they changed judicial elections top to bottom from all the way through. So everything's nonpartisan. Of course, there is discussion of going back, as the balance of power shifts, as it has in so many states. The party newly in control or newly in complete control, depending on the numbers, can start talking about it. I have continued to advocate to keep our judicial races nonpartisan. We have enough sort of things we have to navigate without having to navigate party labels and what that means. I agree. Many voters will tell you, I need to know what you believe, so I need to know what party you are. I've heard that many, many times, but that's a challenge we have as judicial candidates and judicial officers, is to make it not about the party we are, but about the work we do and the importance of the administration of justice in our state. So it's a great question. I'm glad you asked it. What a good one.
Judges are so different from other elected officials who might have a campaign and campaign promises and then say, once I'm elected, I'm going to fulfill these campaign promises. And judges don't and should not operate that way. So I think that those are all great points.
It's interesting. I mean, the current race that I'm in is really, I'm able to talk a little bit more about administrative. It's about the administrative sort of role of the court. But I will say it's harder, in some respects, being a sitting justice running. I'm probably more cognizant than when I first ran for the court the first time of the cases coming before the court. So I'm also, sort of putting these situations where, I'm at an event and people are talking about issues that I think are going to come before the court. And so I'm getting up and, walking out of the room. And I don't recall that the very first time I ran for the Supreme Court. And it maybe just, it took being on the court to be sort of more sensitive to that. And that's really, awkward. So it's definitely a different beast in understanding, and it's hard for people to understand, how you feel. But I've also taken my opinions copied my opinions and taken some of them to events and handed them out and said, like, here's what I've said and what I've written on it, and read that. And, if you don't, I've said it before, there was a case that people didn't particularly like. And I've said, well, here, go read it. And if you don't want to vote for me after reading it, then don't vote for me, And some of them were like kind of surprised afterwards. They're like, oh, when I read what you said, that made sense. And it's, because there's so much out there. And so it's in a way to educate the public about the judicial branch by campaigning too. So, but it's interesting. But we need more people running. So you never know that if you want to go to, that's an option for you.
That's right. Yeah. We always encourage lawyers, at least I do, to consider service or to consider others, because we really need it. It's not the easiest path to get there in elected states, but it's so important.
Yeah. Well, I'll let you dodge that, and we'll move to our lightning round. And so we end every episode with the lightning round, where we ask just short questions and to get the personal side of us. And so we'll answer them in the order of Beth, then Caroline, and then me. And so the first one is there was so much more attention this year to the NCAA's women's basketball tournament. So my question is, did you guys watch it at all? Any parts of the tournament or the championship? Beth?
All right. I'm embarrassed, but the answer is no.
None?
None. I'm sorry. I hardly watch television, and it's almost always golf. I'm sorry.
Oh, Beth, we are going to shame you right now.
I watched.
Feel free. Bring it on. Bring it on. Caroline will make up for it.
I made up for your lack of watching because I've been home with a baby. And so I had time during the day to watch basketball and could have it on while I was doing other things. But I did. I watched a lot of the women's tournament. My Tar Heels didn't make it as far as we'd hoped, but we did have a lot of fun. We watched as a family. My girls know who Caitlin Clark is. It's been a lot of fun this year.
Yeah. So I did watch, and of course I had to watch and got enthralled with just the attention to women's basketball. And then Caitlin Clark is just phenomenal. But so were so many of the other players. But Beth, we're just going to have to, I don't know. But okay, so I am going to North Carolina this summer because my husband and I are going to go out and visit Beth and her husband, Mike. And Beth also has a place. And so we're going to go out there. And so I want to know, both of you, what is the best burger place in North Carolina? So Beth.
So even though I eat a vegan diet, I will answer this question. And it's not so much in my limited experience in North Carolina. Caroline will have much more experience. It's not so much about the burgers. It's about the barbecue. And so I'm going to identify Pick and Pig in Sanford, North Carolina as the place to go.
Okay.
But Caroline, you'll have a more educated response.
So for the best burger, I would recommend Cookout. Okay. But you should get a burger as a tray where you can also get a corn dog as a side.
What?
Yes. Only Cookout can you get a corn dog as a side. And then you should also get a milkshake because they are very good.
Okay. So
Cookout is fast food.
So we're doing Cookout and barbecue when you and your husband come visit is what I'm saying, what I'm hearing.
Oh man, that sounds just amazing. But a corn dog as a side, like that's just incredible. I feel like that's like Harry Potter, like magic stuff.
Who could be against a corn dog on the side? Nobody.
Michael loves a good shake, so he's all about that. Yeah.
Okay. They've got tons of flavors.
So my brother and his family live in North Carolina, and I'm going to ask them about that. They've not told me this, so okay.
Yeah. We have a Cookout in Moore County, so you'll be set.
Oh, you do? Okay. All right. Well, thank you. That is good to know. So my third question is, if you were to write a book, what would it be about?
So we touched on it. I continue to be fascinated by why, after 30 years of law school graduations that are 50% women, why we don't have more women in leadership roles in law firms, in courts, and throughout our legal profession. So if I had the time and the ability and all of that to write a book, I would write about women leadership in the law.
Excellent. I love to read, especially fiction. I love to get an escape from my day-to-day work. And when I was in law school, I would finish my exams and I would go to the library and find a fun book to read. So I'd probably write some sort of fiction book, maybe about a female lawyer doing something exciting, probably more exciting than writing an amicus brief. But yeah, we lawyers think that briefs are pretty exciting.
Oh, that's great. I would probably write I would do something history and probably nonfiction, just because I love to research anything, which probably tells you why I do what I do. But I would probably find some weird history sort of subject and go research it. Probably biography, maybe
the history of libraries.
There you go. I would love that, man. There you go, Beth. Now I know what to do in retirement. So my last question is, because I have been struggling with this. If you could learn a new language right now, what would it be and why?
You're going to have to explain when you answer why you're struggling with this. But I guess if I had to learn a new language, I was going to promote a future episode about AI that we're going to record and say, I would learn a large language model language, if that's a language. But I don't think that's a language. It doesn't qualify. So I'll say German. I took 3 semesters of German in college, and I didn't quite complete that task. So I would finish that task. Caroline?
Yeah, I'd love to be able to speak any other language besides English, but I'd probably say Spanish because, like Beth, I took a lot of Spanish classes and I know some words here and there, but certainly not fluent.
So we're going to Canada, but the French part this summer, and I really want to learn French, but I have been trying to learn it sort of doing these podcasts. There's sort of audio that you can learn. By the way, you can't learn French on a podcast. So all those podcasts like that. And so driving to work, it doesn't work. So that's why I threw that out there to you guys. And so anyway, I was curious what you thought. But so that's a wrap for this episode of Lady Justice, Women of the Court. Thank you again, Caroline Mackey, for joining us. And we will put some links to the case we talked about and her brief and everything on our website. And we'll be back soon. In the meantime, if you can follow us on social media, we will update all of our sort of profile information on there. And we'll be mindful of everything we learned today from her, and subscribe to our podcast using your favorite podcast app. So have a great day.
Thank you for listening to this episode of Lady Justice, Women of the Court. To learn more about the work of our nation's state courts, visit the National Center for State Courts online at ncsc.org. Follow Lady Justice, Women of the Court on social media, and subscribe to the show on podcast platforms to receive notifications about new episodes.